Before we begin, remember that this video is for educational purposes only and isn't legal advice. Case summaries are meant to support your study, not replace reading the full case. This is one of those landmark cases that shapes how lawyers think. Standard forms can cost you thousands when a seller's quote clashes with a buyer's purchase order whose terms govern. This case is the classic battle of the forms. In this video, I'll break down Butler v. Excel O in plain English, showing you exactly how the last shots rule works, the traps to avoid, and the smart steps to protect your business. Don't let conflicting small print ruin your next deal. Alright, let's start with the real-world problem. Most businesses use standard terms, purchase orders, invoices, acknowledgements, and when forms clash, confusion follows. This chapter sets the stage. Imagine you're a manufacturer quoting a machine. You send a quote with your terms, including a price rise clause. The buyer responds with a purchase order, but their form has completely different terms. No price flexibility. You both proceed without settling the terms. This isn't just a hypothetical, it's a daily reality in supply chains, and it can lead to disputes over thousands of dollars. Many businesses assume their standard terms automatically apply, but they often don't. The first step is recognizing that every exchange of forms is a potential clash. In Butler, the seller's quote had a price variation clause. The buyer's order didn't. Neither side flagged the discrepancy. They just exchanged forms and continued. This happens when companies rush to secure orders or ship goods, ignoring the fine print. The danger is that if a dispute arises later, say raw material costs soar, you're stuck arguing over which terms apply. Courts have to pick one set of terms, often surprising both parties. Commonly, people miss that silence, or a simple "thank you" doesn't settle the contract. Your terms might get replaced by the other side's. Some think the battle of the forms is about tiny legal technicalities. But in Butler, the 2,892 extra claimed was about 3.8% of the contract price, material enough to fight over. For a small manufacturer, that's the profit margin on the job. It's not just about legal fine print, it's about real money and business relationships. When you understand this, you see that every order acknowledgement or delivery note is legally significant. The practical deal may help with every form like a potential contract changer. Quick reminder, this is a study summary, not legal advice. Always read the full judgment for complete context and nuance. Now let's unpack the case itself. Knowing the facts and court's reasoning gives you the tools to spot similar patterns in your own dealings. Butler Machine Tool made a precise tool for Excel O. They offered it for $75,535 and included a price escalation clause. If costs rose before delivery, the price would too. Excel O responded with a purchase order on its own terms, which said nothing about price variation and included a tear-off slip for Butler to confirm. Butler signed the slip, sent it back with a letter referencing their original quotation, then built the machine. When costs increased, they invoiced for the extra and Excel O refused. The fight was on. The court had to decide, was the contract formed on Butler's original quote with the price variation or on Excel O's purchase order without it? This is the classic battle of the forms. Each side fires their terms and the last shot usually wins. But it's not always simple. The judges examined every communication, the quotation, the order, the acknowledgement slip, and the covering letter. The core dispute was whether the slip acceptance created the contract on the buyer's terms or the seller's. The Court of Appeal held for Excel O. The majority applied the traditional offer acceptance rule. Butler's quote was an offer, Excel O's order was a counteroffer, and Butler signing and returning the slip was acceptance of that counteroffer. Therefore, the price variation clause was out. Lord Denning, concurring, said you should look at the whole dealing to see if a contract was formed and on what terms, but he also found for the buyer. The key takeaway is that the last counteroffer before performance is accepted by conduct binds the other party. Lord Denning's judgment was innovative. He said the rigid offer and acceptance analysis is out of date. Instead, courts should review the documents as a whole and decide if a concluded bargain exists, then piece together the terms. This approach has influenced modern thinking, even though in Butler it produced the same result. It highlights that judges sometimes prefer a pragmatic, commercial view over technical rules. But for now, the last shots rule remains dominant in the UK, so don't assume a Denning-style outcome will save you. Be explicit. Let's break down the legal mechanics because once you understand the rule, you can navigate contracts more defensively. A contract requires a clear offer and unconditional acceptance. An offer is a statement of willingness to contract on specific terms. If the offeree responds with different terms, that's a counteroffer, which may negatively impact the original offer. In business, purchase orders often operate as counteroffers. For example, if you quote to sell a machine and the buyer sends back a purchase order with their own small print, legally that's a rejection of your offer and a new offer to you. Then your actions, like shipping the goods, can be acceptance of their terms. The last shot rule says, in a chain of correspondence, the last document sent before performance begins is the last shot, and if the other party then performs, they're deemed to accept those terms. In Butler, XLO's order was the last shot. Butler's acknowledgement slip didn't restate its price clause, and performance, building and delivering locked in the buyer's terms. Many businesses mistakenly think that sending their own form back may support their terms. But unless you expressly reject the other side's terms and make a new counteroffer, the last clear shot wins. In Butler, the tear-off acknowledgement slip was potentially serious. Butler signed and returned it, and the court saw it as accepting XLO's terms. Many companies use similar pre-printed forms with a signature section. If you sign and return it, you likely accept all the terms on that form, even if you write a covering letter referencing your own quotation. The slip is often a contractual booby trap. Always read what you're signing and add a statement like, "Signed subject to our standard terms or better, get a reciprocal signature on your terms." A simple email saying, "We object to your terms and proceed only on our standard terms," can preserve your position. Let's review the key takeaways. If this helped, like the video and subscribe for more case summaries that make law study easier. Subscribe for more case summaries that make law study easier. Thanks for watching. Remember, this is educational only. Read the full case and consult your course materials. Subscribe for more case summaries.